next matter to come before the court is in Re A.D. Okay, each party will have 15 minutes to present its arguments. The appellant may reserve up to 5 minutes for rebuttal. If you wish to reserve that time, let me know when you come up to the podium, and I'll keep an eye on the clock. The arguments are being visually and audibly recorded to be posted online, so please keep your voices up and remain behind the podium. Keep in mind, do not use the names of any children or minors in your argument. Just refer to she or them by initials or any other way that would not reveal the child's name. All right, so we have read your briefs and we are ready to proceed when you are.
Thank you, Your Honor. May it please the court, counsel, my name is James Armstrong and I represent the mother, Tierney Scoble, who raised her daughter A.D. from her birth on November 10, 2015 until she was removed by Summit County Children's Services in April of 2018. Your Honor, the issue in this case can be boiled down to one matter, and that's whether one comment made in apparent frustration can lead to a dependency. I submit it cannot.
Mr. Armstrong?
Yes.
I'm sorry, did you tell me you wanted to reserve time?
Oh, my apologies. With respect, the appellee has waived so many times in my recent arguments that if I could reserve just 3 minutes.
That's fine, thank you, go ahead.
As I was stating, I represent the mother who raised the child A.D. from her birth in November 2015 until Children's Services removed the child in April of 2018. The issue in this case is based on essentially one comment made by the mother in frustration with other family members around, in which there was no real harm that was going to come to the child and no really adverse impact on the child. The irony is when the child actually was removed, the mother had led, it's technically her cousin, but in reality it was kind of like the de facto mother who raised the mother. Ms. Craig had her in her care and knew the child from the date of birth, was there at the birth from 2015. The child has always been fed, she had always been clothed, she had always been well cared for. The mother, whatever issue she has, was always addressing them through counseling through Ohio Guidestone. Her counselor from Guidestone, who's a mandatory reporter, never ever thought that the child was at harm, never thought the child was at harm even after a hearing of this one comment made in frustration. At the same time, Children's Services filed a motion in which they stated the father had no criminal record. He did. Not only did he have a criminal record, it happened in less than a year earlier at the previous Easter, so that would have been Easter 2017, in which it is undisputed that he threw either a brick or a rock through mother's then boyfriend's car windshield on Easter Sunday morning. Children's Services had that in their complaint. In their complaint, they were asking for an ex parte order of temporary custody to this very person. During the trial and also hearing, it's in the record that he actually had left for Florida, that there was an unsubstantiated complaint made against the mother in November, December of 2017, in which for 45 days the agency looked into this and never even saw the father, didn't know where he lived, didn't know if he was around. Yet in looking through the record, and since I was the trial attorney as well, It was amazing how Children's Services seemed to take father's statement that they were living together at the time somewhat as gospel, despite the fact that based on his criminal conviction for throwing that brick, was obvious that they weren't living together at the time, since she was clearly dating another. It was that type of foundation in which this case came to the trial court. During this time, it seemed that there was an intent by Children's Services to remove this child at all costs, regardless of what the facts stated. We had this Children's Services in their complaint misrepresenting the father's criminal record, and at the same time claiming the mother had an ongoing criminal matter that actually had been dismissed. So she had no criminal matter.
Counsel, I can't remember right now, what's in the record as to why the child was, why mother had placed the child with the cousin?
The mother was going through some issues and was a little frustrated. She was a single parent, and she was looking for some support. And based on it's in the record, and based on the testimony, she was feeling a little bit overwhelmed at the time. So she had placed the child with Miss Craig. From what I understand, Miss Craig had periodically taken care of the child at times. And I submit that that's a sign of a responsible parent, not somebody who's putting a child at risk. There's times when all of us as parents need some support, whether it's to spend time with our spouse, whether it's to go out of town, and we have grandparents and we have other people, just as it's not uncommon for people to, when they're having some stressful periods of time, reach out to either therapists, or some of us go talk to our priest. That doesn't make a child dependent. Where was the adverse impact? There was none. Was this child ever not fed? No. Was she ever not housed? No. Was she ever not cared for? No. None of that's in there.
Counsel, though, the thing that I was wondering is, I agree wholeheartedly, we all have, we have to go into the hospital or out of town or whatever, so you pray you have a good support system to take care of your children while you're incapacitated or unavailable. But here it seems like she was not doing that because of the fact that she had to work, or she had to go out of town, or she was ill. It was because she was overwhelmed. And isn't that almost dependency right there, that she's saying, at this point, I can't take care of this child?
No, Your Honor, I don't agree. And I don't agree for the simple reason is that through life, things get overwhelming for those, be it work, be it stress, be it financial issues or whatnot. And many of the family members are concerned about that, and concerned about, an absent parent who isn't around. Those are not terribly uncommon. To reach out to somebody and then say, here, would you watch our child, or watch my child for a little while, is responsible. And the fact that it may be, let's concede a mental health issue, how's that different from a physical health issue if you physically can't take care of your child? The issue is, are they taking care of their issues? There's no dispute that she was. I mean, she was in counseling in Ohio Guidestone. The counselor, as let me reiterate the point, the counselor is a mandatory reporter and never saw a mom at any risk regarding this child. My concern is that if you have such a low threshold to allow Children's Services to up and remove the child, we're essentially having such a low bar for dependency that any temporary crisis in a family can result in dependency, as indicated by the actions of Children's Services in this matter. I find it interesting that both the court and the state raised two cases, in Re Messenger and in Re JC, in which there are actually legitimate actions in both those cases, because they're pretty much arguing a prospective dependency. Well, gee, mom having mental health problems, the child is per se at risk, ignoring the fact for 2.5 years she's been raising this child successfully with having a job, maintaining employment, having her education. She graduated from high school. I'm trying to remember all the facts off the top of my head, but a relatively stable form. Being a single parent, she was doing all that she needed for the first 2.5 years. And in the two cases that were cited, in Re Messenger, you had an infant that was born addicted to cocaine, and in Re JC, I not only put in the actual facts of that case in my brief, in the reply brief, I put them in again to show that we had a mother that was trying to clean her apartment with bleach because of the evil spirits and the other issues that were involved in this case. You know, here we essentially have one comment. The other testimony the state used was that mom had an apparent attempted overdose while she was pregnant the last 2.5 years earlier. I mean, she had raised the child for 2.5 years by that point, which was completely irrelevant to that point in time. So there was literally no evidence of dependency with regard to an adverse impact on the child, which is, case law has indicated has been required. And then you compound that problem when you have in your complaint trying to get custody away from the mother and temporarily to the father state in an ex parte request that he has no criminal record, when he has not only a criminal record, but one that specifically affects the mother and her paramour at the time. It's really almost disbelief that Children's Services did that. And then when they were called on it, they claim, well, it wasn't that important or it's not that big of a deal. I can't remember their exact words, it's in the record, that it wasn't a concern with regard to raising a child, which in 2.5 decades I've been doing this work is a first. Usually that's pretty concerning when a father is making aggressive actions towards the mother's boyfriend. And you so disregard that, it says to me the Children's Services got caught, they did the wrong thing, and then instead of having the courage to say, okay, we made a mistake, or we didn't look into this case enough, dismiss it and then investigate it some more, they double down and try to make excuses of why they did something improper in the first place. Which is why I point out that Juvenile Rule 10 was not complied with by Children's Services, because they did not have good knowledge of what they had filed. There appears to be a complete lack of due process that was granted to the mother in this, starting with the complaint and continuing on. I even referenced the trial court's comment in which they actually praised mother for successfully raising this child for 2.5 years. Well, she successfully raised the child for 2.5 years. She had one comment that let's concede for sense of argument that it may raise concern, may raise some concerns, but when you look into it, you find out that during that period of time, mom had let the person who essentially raised her cousin, forgive me if I call her the mother, because that's essentially what she was. She wasn't the biological mother, but she was the one who did all the duties of the mother. And the court putting that in there made it all the more confusing of why the objection to the magistrate's decision wasn't sustained. Because the court's essentially conceding, yeah, she properly raised the child for 2.5 years. So where, again, is the dependency? And do we throw out 2.5 years because of one statement made in frustration? I certainly hope not. Fortunately, my daughter's 18 now. I'd love to have seen, I don't want to say for 18 years I never said anything in frustration to my child. I probably did. But that is so concerning, not only for this case, but cases going forward, by stating that, okay, one statement's enough. And again, I hate to reiterate this, but it's important that the next step is the Children's Services putting in a complaint things that are demonstrably untrue.
Counsel, you keep talking about the one comment, but the one comment talked about everybody would be better off, basically, including her and everyone else, if she just threw her child in the canal.
I'm not saying it was a responsible thing to say.
Not really just one comment.
Your Honor, I would say it's one comment based on the fact that there was no real chance of any kind of follow-through. Why? Because there were people around her in which it was a sense of venting and frustration. Was it a stupid comment? Absolutely. Was it something to raise concerns and do an investigation and say, is there real danger here? Yeah, maybe. I'm not going to argue that point, but by the time Children's Services removed the child wasn't even staying with mother. She had temporarily stayed with she was temporarily staying with the de facto grandmother. I'm miscorrect.
You're in your rebuttal time, counsel. You can keep going, but I just want to let you know.
Okay. Anyway, I will reserve the remaining, I guess, 2 minutes and 2 seconds from everyone.
May it please the court, counsel, Helen DiMartino, guest on behalf of the appellee, Summit County Children's Services, we are asking that this court affirm the trial court's decision finding the minor child to be a dependent child and placing the child in the temporary custody of the father. Before I begin responding to the first assignment of error, I just would like to make a statement with regard to the second assignment of error and to point out that what counsel is arguing is a mischaracterization of the testimony that was presented at the trial court below. The caseworker testified, the agency repeatedly explained that it was an error in the affidavit where it said that father had no criminal history, when it should have said that father had no criminal history that would prevent him from being a placement option. And that's in the record on pages 40, 41, 42, and on page 190. So it wasn't a situation where the agency had failed to do an investigation and therefore the analysis is skewed. It simply was in the complaint incorrectly. And again, that is borne out by a reading of the record. With regard to the first assignment of error, this child was found to be dependent under 215104C, meaning that the child's condition or environment was such that the state was warranted in the interest of the child in assuming the child's guardianship. And this court has said in Re A.D. that a parent's mental health is directly related to a child's environment and may properly be considered in determining whether the state's intervention is appropriate and warranted. In this case, this is not about a simple statement. This is not just some comment that wasn't possibly going to be borne out as counsel argued. There was testimony, I believe, on page 50 of the transcript where social worker Kemp stated at the TDM meeting that mother acknowledged that she was still overwhelmed, and he also stated that a relative had intervened because when mother made the statement that it would be in the best interest if the child was to be gone and she would throw the child in the canal, she started walking towards the creek holding that child. The fact that the mother placed the child with Miss Craig does go to the fact that this child is dependent. In fact, mother continually stated that she was overwhelmed and she didn't have support, and yet counsel is here arguing to this court that Miss Craig was essentially the mother or the grandmother in this case. So if mother has this amount of support to the point that her attorney would argue that this woman who was caring for the child was acting basically as the mother, it's hard to imagine that this mother was going to be in a position because of her mental health issues where she could no longer feel that amount of being overwhelmed. In fact, the agency did first get involved in this case in 2015 because of mother's mental health issues where she ingested pills in an attempt to take her own life while she was pregnant with this child. In 2016, she was engaged in counseling for her major depressive disorder as well as anxiety. In 2017, the agency was again involved due to a referral where the child witnessed a domestic violence issue. And then in 2018, mother made this statement despite being in counseling. And mother's counselor testified that she is working with mother and was working with mother at the time of the statement to redirect mother's belief that this child is ruining her life. So this is not just some isolated statement. It is systematic evidence of mother's mental health issues, which despite her attempt to get counseling and her attempt to be able to take care of her child, the fact is that her mental health issues are ongoing and are causing her to have an inability to protect her child and is creating an environment that is such that the state had to intervene. The fact that mother placed this child with Miss Craig does not mean that mother could not have gone back to that house and taken that child again if she felt overwhelmed and wanted to act on her belief that the child was ruining her life and that she would be better off without her child. So this kind of cavalier approach to, well, it was just a statement, is not supported by the evidence in the record. The evidence in the record shows that mother did in fact have support. Miss Craig, there's evidence that she helped her. She was there at the time of the birth. She bought diapers. She helped mother in a lot of different ways. and mother was still overwhelmed. Mother was in counseling, she was still overwhelmed. So the fact is that mother's major depressive disorder and her anxiety has placed this child in a situation where the agency had to intervene. And there is no requirement in the law that the agency has to take a long odds gamble on the life of a child before intervening. In fact, to the contrary, in Re A.D, the court has held, and this court has held in Re A.D, that the state is not required to take a long odds gamble on the life of a child before intervening. And the conduct of the parent, in this case mother's mental health issues, her statements, and her action in walking towards the creek while holding the child up and having a family member intervene so that nothing happened, is sufficient evidence based on mother's long history of mental health issues for the agency to have intervened. With regard to the disposition and the placement of the child with father with protective supervision to the agency, again, the statement that father had no criminal history was an error. It should have said that father had no criminal history that would prevent placement. The agency presented the testimony of Mr. Kemp as well as Mr. Io, who both testified that father threw a brick into the window of a car on Easter, as counsel indicated. However, that particular action was not something that was going to be preventing the biological father from being able to have his child placed with him, in part because no children were at risk. It was an isolated incident, and there were no safety factors or threats that involved the father or the support system to the child, and that's in the record on page 17, 38 through 40, as well as page 185.
Counsel, was it at least exhibit that father may have an anger issue?
It could have. The agency looked into it and found that it was not dispositive for disposition. I don't recall if the case plan addressed anger management. Right now, I'd have to go back and look through the brief. But if nothing else, if it did indicate that he had potentially an anger issue, then that would be something that could be addressed through counseling or through an assessment, but was not something that would prohibit placement, especially because this was a biological parent, not a further removed relative.
What is in the record as to how much interaction or contact father had with the child over the 2.5 years?
There is an indication, as counsel stated, that when the first that 45-day period, the father was not always involved, so it was not consistent. But there's also evidence in the record that the child was not bonded with mother. That's on page 21. That there was a time where brief period of time where mother was not even allowed to be alone with the child. That's also on page 21. So while it may be that neither parent perhaps had the best interaction with the child throughout the history of the case, I suppose, there's no indication that father was ever in a position where there was an issue with bonding, or that there was a time when father was prohibited from being alone with the child. What is in the record is that father does have the income as well as a home that doesn't have any hazards, that is adequate and appropriate for the child, and has child care plans in place, and that's on page 176, 177 through, I believe, 178 of the record. And there is evidence of mother's ongoing mental health issues in the record. So based on that, the agency would argue that there is sufficient evidence in the record to support the placement of the child with her biological father with protective supervision to the agency. And if there is any development, into any issues, let's say perhaps with regard to bonding with the father or to anger management, those things can be addressed through the agency, since the agency is still involved, whether it's an amendment to the case plan or something else to make sure that there is no further issue. However, again, that incident on Easter of, I want to say it was 2017, there has been no further issues with father, which would arguably be an indication that it's not an ongoing issue. So that's been almost 2 years with that one incident with father. If there are no additional questions, the agency would ask that this court affirm the trial court finding that this child is a dependent child, and also to affirm disposition placing the father of the child with the father with protective supervision to the agency.
Thank you, Your Honor. I would appreciate the counsel for the state pointing out the fact that, as I pointed out in initial argument that actions mean less to children's services than words, because that's essentially what their argument is. Throwing a brick through the Paramore's window on Easter Sunday, that's no big deal. The fact that the case plan has nothing about anger management regarding the father, that's no big deal. The fact that they were involved for 45 days with this family on an unsubstantiated report, and they didn't even know father was around, is no big deal. The fact that it's in the record that he went to Florida for months is no big deal. The fact that mother made one statement, as responsible as it was, with no real likelihood of follow-through, well, that's when the sky has to fall. And I find it interesting that the council mentions the therapist. The therapist stated, and is a mandatory reporter, that she had no concerns about mother raising her daughter, and mother has always been proactive in seeking help when needed in the 2.5 years she raised the child. That's on page 127 of the record. So the person who knew the mother the best wasn't concerned. The agency who started off this case, and it was an ex parte request for temporary custody to the father. They went initially to the court to get an ex parte order, and in the affidavit had something that was easily disproven. Now, they can claim it was a mistake, but their argument that it wasn't a mistake was just a misunderstanding, it didn't affect the placement of the child, is more troubling, because the idea of throwing a brick through the one parent's boyfriend's car windshield on a holiday morning,
Councilman,
I'm just in disbelief.
you don't have much time left, but I just want to ask you a quick question, hopefully. Counsel for the CSB did indicate that when the mother made the statement about everyone being better off if the child was in the canal, putting the child out in the canal, that she had the child in her arms.
No, she had the child by the arm, I believe. She was
Okay.
told she had the child arm in front of other people.
But she said that statement in front of the child.
She said, yeah, that's true, she did. No, I'm not arguing. I never said the statement made sense. I never stated it was responsible. What I stated is it's one statement after raising a child for 2.5 years, and that one statement in and of itself does not result in dependency unless we can show an adverse impact, and that has not been shown. And the cases cited, and were just referenced by the state, are so distinguishable from this case.
I think you now gone beyond the cause question. You're over time.
Thank you.
Very much for your argument. We appreciate your presentation. The court will take the matter under advisement and issue a written decision, which will be mailed to both sides, as well as posted to our website and on the website of the Ohio Supreme Court. We will be in recess and then